webinar that we have prepared today. Cooperation with Allen Overy. Together with Martin Magál and Matej Košalko, we will discuss the effects of coronavirus on contracts, whether we can consider it as a. Let me introduce our speaker. Martin Magál is currently leading the Allen Overy office in Bratislava, as well as serving
Michal,
on the board of directors.
I think we need to pause until people mute their lines because there is a lot of echo in the background. Let us just wait. We will mute everybody's lines except for that of the speakers. Okay, Michal, I think you can go on and make sure your computer is not with sound enabled so that it doesn't relay the sound back when you speak.
Sure, I think it should be turned on anyway. So once again, thank you, Martin and Matej, for joining us today. As I mentioned, Martin is, besides being a board member of AmCham, he's also leading the Allen Overy office in Bratislava, and is one of the most recognized lawyers in Slovakia. His colleague Matej, who will be with us today, is dual qualified associate who is specializing in commercial and investment treaty arbitration. So before handing the word over to you, I would like to remind our members who are joining the call on a few logistical details or issues. The webinar will last approximately 1 hour. Martin and Matej will start with their presentation, which should take about 30 to 40 minutes. If you have any questions, and your questions are more than welcome, please make sure you use the chat feature on the right of your screen. Ask any questions to any of the speakers through the chat feature. Martin and Matej will take as many questions as possible during the Q&A session after their presentations. Please also make sure that, as we reminded you yesterday, the webinar is recorded for quality purposes and so that it can serve, hopefully, as useful source of information for other members as well in the future. That's very brief from our side, and please, Matej, Martin, the floor is yours.
Thank you very much, Michal, for this kind introduction, and good morning, everybody who have made it to this first ever webinar. Apologies for some of the technical glitches. This is very much the beginning of the new era for us, and we are learning as well, but so far it seems like it works pretty well, and you are at least able to hear me while not hearing much of the background noise. So by way of introduction, my name is Martin Magál, and I am the managing partner of Allen Overy in Bratislava, and with me I have an associate in our dispute resolution practice, Matej Košalko, and together we are going to talk to you about the effects of the coronavirus pandemic on commercial contracts and whether it represents a force majeure. I understand from the list of registered participants that on today's webinar we do have representatives from companies' in-house legal functions, HR functions, as well as finance, and we also have colleagues from other law firms. So again, good morning, everybody. We are looking forward to this presentation with you. As you know, the spread of coronavirus and the disease it causes, which is COVID-19, has had a fundamental impact on both our private lives and the economy as a whole. People and businesses are only starting to adjust to the new reality brought by this development. If we are able to work, we are mostly working from home, and some of us have to take care of our children at the same time. We are not able to visit our relatives, especially those who are elderly. In fact, I have a grandfather who is 97 years old, and he lives in a social home in Bratislava, and I haven't been able to see him for over 3 weeks now. And because many of these people do not have phones enabling video conferences, it's very difficult for them to get in touch, and audio is sometimes the only means of communicating with loved ones. And my grandfather tells me how much he looks forward every day to my daily call, and what a pleasure it gives him to hear the voices of people who are close to him. And I'm sure many of you have experienced something similar. So while it is admirable that we representatives of the industry are doing our best to keep the wheels of economy rolling, let us not forget that in these testing times, the best we can do as human beings is to stand close to our families and to those who are in need. Sometimes a simple gesture, a phone call, or a message can be the biggest contribution we can make during our day. But let's move to the topic of our presentation and to the next slide. On this slide, and some of you will see it with a delay, on this slide we have put up just 4 of the many examples of conversations we are currently having with our clients and business partners. These describe how the virus is affecting business. And we've taken only examples from the area of supplier-customer relationships. We hear many more stories of impacts from our mergers and acquisition teams, as well as our banking and finance teams. Let's look a little bit closer on each of these 4 examples. We have deliberately chosen case study situations, each with a different area of impact. In the first one, it's the impact on employees and how that can affect a company's ability to supply its customers. In the second, it's the actual suppliers of a company on which the company in question is reliant to make its own supplies. The third one is probably a topic that many in the legal industry have had to deal with over the past days, and that is retailers who are simply unable to keep their shops open unless they sell foodstuffs, medicines, or drugs. And in the fourth category, we describe the effect on distribution networks. But in practice, we are seeing, and many of you are likely to see, a combination of more than one of these impacts at the same time. Some of you may see all of them arising in the same situation. I think we can all agree that each of these events, i.e. employees not being able to come to work, or suppliers withholding or not being able to supply, or tenants not being able to pay the rent for their premises or not being able to derive any income, or distribution networks not working properly, we can all agree that these represent a disruption of the business lives. But do they represent a force majeure event in the legal sense? And if they do, what are the consequences? To give you a brief analysis of what is force majeure and how it differs from other recognized legal concepts, let me now pass the word to my colleague Matej.
Thank you, Martin. So what is the effect of the various scenarios outlined by Martin in contractual obligations? On the slide, you can see 3 different legal concepts of Slovak law that would apply to these circumstances. First, there is a force majeure, or as Section 374 of the Commercial Code puts it, circumstances excluding liability. These are circumstances arising independently of the will of the party, unforeseeable when entering into the contract, and cannot be averted or overcome. These will be explained in more detail by Martin in the next slide. At this point, I will just note that this provision only relieves a party from liability for damages during the time of the event. Unless the party terminates the contract, the affected party is still required to deliver. The party is technically in default, but not liable to pay damages. On the other hand, it is still liable to pay contractual penalty. This is very important. This provision was inspired by Article 79 of the Convention on Contracts for the International Sale of Goods, so-called CISG. Therefore, jurisprudence to this article also gives useful guidelines on interpretation of our commercial code in this respect. Second legal concept which may come to play is impossibility to perform the contract. It is regulated in sections 575 of the Civil Code as well as sections 352 to 354 of the Commercial Code. In international trade, section 731 is important. The law does not define what impossibility means. It only gives some non-exhaustive list of examples when performance shall not be deemed impossible and when it shall be deemed impossible. Here, it is important to stress that only permanent obstacles can cause impossibility of performance. Therefore, government measures adopted these days with temporary nature would not qualify as impossibility. But for example, not granting or revoking an export-import license would qualify. For instance, if country revokes an export license to medical products, this would qualify as impossibility. Performance shall not be also deemed impossible if it can be provided with larger expenses or later in time. Some jurisdictions recognize the concept of hardship, but this concept is not recognized under Slovak law. Unlike force majeure, impossibility causes automatic termination of the obligation, but the obliged party is liable for damages unless it can claim force majeure. Last but not least, the principle of fundamental change of circumstances, internationally known under Latin expression rebus sic stantibus. This principle can be found in section 356 of the Commercial Code. It applies if the basic purpose of a contract, which must be explicitly expressed in the contract, is frustrated in consequence of a fundamental change of the circumstances under which the contract was concluded. Affected party can terminate the contract, but again remains liable for damages resulting from such termination. A good example is a lease agreement. Lease of a hall or other premises which the tenant cannot use as intended due to government measure, for instance, to organize a motor show in Cheba Arena. Tenant can still pay the rent. His obligation to pay the rent is possible and not affected by coronavirus. So the tenant cannot claim force majeure either. It will be the purpose of the contract which was frustrated in this case. Now, hopefully you're not too much confused. I will leave it to Martin, who will talk in more detail about the force majeure itself.
So the big question many of our clients ask us, and many ask it themselves, is when can a business, a company, claim force majeure relief because of coronavirus? And Matej has already outlined some of the tests for the conditions under which a force majeure can apply. Now, in relation to coronavirus, I think we can safely conclude that it does represent an obstacle, or the effects of coronavirus do represent an obstacle which occurred independently of the will of any contractual party. None of this happens because businesses want the coronavirus to spread. The second question, which may be slightly more tricky, is whether the coronavirus was unforeseeable at the time when the obligation was established, in particular when the contract was entered into. And for slightly older contracts, that condition is most likely satisfied, and I mean contracts that would have been concluded until the end of last year, before we understood and before the news spread that in China there is a new virus spreading. But for contracts which have been concluded as of January and perhaps later, the satisfaction of this condition may not be as straightforward as some people might imply on the first look. The really interesting part in relation to coronavirus is whether the effects could have been either averted or overcome by the relevant party. Now there is a marked difference between the two sub-conditions, because in order to avert, that means the party would have had to take some ex ante measures before the effects have represented on that party. And in order to overcome, those would be measures that could be put in place even ex post after the relevant party has suffered the effects of the force majeure event, but could see whether it can overcome them or not. In terms of to what extent the obstacle, the coronavirus, is an insurmountable one, the party claiming relief under force majeure would need to show a reasonable effort to overcome the effects of the impediment in question. And it would have to show that it had little or no margin to take preventive measures. So for instance, a party who would like to claim force majeure relief must also be able to show that it did try to look for alternative sources of performance, or that if it suffered some delay in its performance, it still was trying to perform, albeit at a later date. One example, for instance, is a shipment of goods held up at border, where the shipper, the transport company, must take all necessary precautions to preserve the goods that are held up at the border, because otherwise there might not be an evidenceable causal link between the delay on the border and the damage of the goods. Another question that arises often in these situations is with what level of certainty does causality need to be proven in these cases? And under Slovak law, there have been various concepts of causality put forward. One is the so-called direct causality, the other the so-called indirect. However, majority jurisprudence, I would like to ask whoever is not speaking to put their phones on mute, please. And the host of this meeting, my colleague Monica, if she could mute the lines of people who are speaking. Thank you. So in terms of causality, we believe that the best test of causality would be the so-called conditio sine qua non, is a Latin phrase noting that in a chain of events, a cause is one without which the effect would not have occurred. And again, I have to pause here and ask.
Tak vymeňme tie stoly. Máme dosť času.
I think someone is talking on the line without being on mute. Let us just try to solve that at our end as soon as possible.
Počkaj.
Dáš si pauzu, dobre? Vymeníme stoly. Ale budeš tam tiež sedieť.
Ticho!
Okay, I think now the line has been muted. To what extent the force majeure can also apply in supplier relationships, so liability of suppliers, or to what extent it also applies when a supplier has been affected? Matej will tell us something about that as well.
So what this long provision in section 375 of our commercial code says is that if a supplier is affected, the original object party can claim force majeure only if it's affected as well. So both parties both suppliers and the object party need to be affected by the force majeure event. If only the supplier is affected, it is for the obliged party to find a new supplier. Now, we shall look at some past examples of decisions of Slovak courts or in Czech courts considering force majeure events. In one instance, adverse climate conditions caused poor harvest. The agricultural company failed to deliver the agreed quantity of crops. The court did not consider this a force majeure event because it was even predictable and surmountable. According to the court, agricultural companies can reasonably assume that poor harvest may occur. But more importantly, the court concluded the obligation was to deliver the crop, not to produce it. The company was therefore obliged to secure supply from another grower. In another instance, currency depreciation occurred. The producer failed to deliver lumber under the contract. It claimed that it was due to 100% increase in the transport rates in German transport flows. According to the court, the producer should have sent the consignment through Austria or Switzerland, which were not affected by the increase. Force majeure is sometimes called as act of God, but as another example will show, even acts of men can cause and qualify as force majeure. In this case, Samsung ordered transport of electronics from Slovakia to Bulgaria. The vehicle, including the goods, was stolen during transportation. According to the court, the theft of the vehicle and the goods in this circumstance constituted liberating reasons and relieved the carrier from liability for damages. This particular relationship was governed by the Convention on the Contract for International Carriage of Goods by Road, CMR contract, but the relevant article of the Convention corresponds to what is required under Section 374 of the Commercial Code. All these cases illustrate that courts interpret and apply force majeure defense very narrowly. As explained before, our Section 374 of the Commercial Code was inspired by Article 79 of the CISG. Therefore, CISG case law from various jurisdictions can also give some insights. This case law also suggests that the application of force majeure is very narrow. Now, I give word back to Martin, who will give you some useful tips on force majeure clauses.
Thank you, Matej. When we look at force majeure clauses in contracts, what do we look for? What kind of questions do we ask ourselves before being able to advise clients on what the effect of force majeure is and whether they can really put that clause into effect? The first and most important question is, what is the governing law of the contract? Because force majeure under Slovak law may mean something completely different to US law, to English law, to French law. In sale of goods relationships, one very relevant question is whether the Convention for the International Sale of Goods, which was already mentioned by Matej, applies or not. To those of you who are familiar with international trade, you may know that the convention, also called by its acronym CISG, applies automatically to relationships between parties coming from contracting states, unless these parties have specifically excluded them from the contract. The third question that is relevant to ask is whether the contract contains an explicit force majeure clause and whether that clause is in line or goes beyond what is provided in the relevant statute. One good benchmark to mark force majeure clauses against is the International Chambers of Commerce Model Force Majeure Clause, which has been in existence for the last 20 years at least. And in fact, recently, the ICC has published an update to the model force majeure clauses in two variants, one a long form one and the other one a short form. And I would encourage everybody who is not yet aware of the ICC force majeure clause and currently debates and considers to include a force majeure clause in their contracts to look at that precedent, which has gained some universal acceptance. The next question is whether in an existing force majeure clause, something similar to the coronavirus pandemic is listed as a specific type of force majeure for the purposes of the contract. So for instance, does the force majeure specifically mention epidemics, biological contamination, or government restrictions as a result of biological contamination? The ICC model force majeure clause, for instance, also includes a reference to prolonged breakdown of transport as a measure which can be understood to constitute force majeure. The next important thing when analyzing force majeure clauses is whether the effect of the force majeure is to exclude liability to pay contractual penalty or not. Whether the force majeure relieves the party from performance or whether the force majeure relieves the party only from the negative effects of the liability for non-performance. And there are various different national regimes for that. The other points which are important to see is whether the notice obligations in the force majeure clause provide for a notice of the event and follow-up notices of the effects of that event, and to what extent a delay with putting a proper notice of force majeure to the other side may prevent a party from claiming relief under force majeure. One of the items that has come into fore in recent days when we were looking at force majeure clauses, we have seen that some force majeure clauses, they require the affected party to procure a certificate, a confirmation from the local chamber of commerce to the effect that an event described as force majeure has occurred. And for businesses in Slovakia, this might be particularly relevant because we have already inquired with the Slovak Chamber of Commerce and Industry whether they are considering to issue force majeure event confirmations in relation to coronavirus. And on an informal basis, we have been told that yes, they do envisage issuing such certificates, although each and every one case is being considered on an ad hoc basis. Last but not least, it's important to look in the force majeure clause for the right to terminate the contract by the affected party, provided that the force majeure event doesn't only have an interim nature, but takes a longer period of time. For instance, under the ICC model force majeure clause, a party is entitled to terminate the contract if the force majeure event lasts for longer than 120 days. And there are other aspects on which we can look when analyzing force majeure clauses. Let us now turn to the situation of businesses who know that Corona is happening. They see the world around them changing, but so far neither their suppliers nor their own business has been fundamentally affected. What should they do? And I think in terms of taking preventive measures and being ready for the situation, you can see on the next slide 5 recommendations that we would have for businesses that are yet unaffected by the force majeure situation or by the coronavirus situation. First is to monitor the market, act diligently, and take all necessary precautions. For instance, also taking into account possible longer supply and lead times to be able to perform under your contract. Second is to communicate regularly and openly with your suppliers and customers about the possible risks that can crystallize should the situation deteriorate further. For instance, if there is a total lockdown declared in Slovakia, just like it was declared in Italy, what effect will it have on your ability to either take supplies or to supply your customers? Third, I think it's prudent for all businesses to try and identify alternative means of compliance with the existing contractual obligations, and even before that compliance becomes risky or impossible. A good question to ask is also if in the current situation force majeure cannot be triggered yet because the effects of a force majeure have not represented themselves, what is it that would need to happen? What more would need to happen in order for the current situation to escalate into force majeure? And we know that is an exercise many companies are trying to do already. And last but not least, I think in times of crisis, it's always good not only to talk to your priest or guru or whoever, but also to your lawyers, insurers, and banks. Let me now pass on the word to Matej again to talk about businesses that are already affected by the coronavirus.
So what would you do when your business is already somehow exposed to the force majeure events caused by the coronavirus? Your business may be affected in two ways. Either you are unable to meet your own obligations due to force majeure, or you are not directly affected, but your suppliers already send you a force majeure notice. Let's take a look first at what you should do if you are not able to meet your obligations. As Martin already explained, you will have to use reasonable effort to find alternative means of meeting your obligations, even if you will be able to deliver later by alternative means from other suppliers or with additional expense. You should notify your customers. Let them know what is happening, not only because this is your legal obligation, but to find a solution. As Martin said at the very beginning, remember that this situation affects everyone globally. They may not even need you to deliver as originally agreed. Attempt to negotiate with your customers new terms. Check force majeure clause in your contract as summarized by Martin and comply with the relevant requirements. Consider obtaining certificate from the Chamber of Commerce. Second, you may receive a force majeure notice from your supplier. Then there are two aspects you have to consider. Obligations towards your own customer, where again, you have to consider whether there is alternative supplier means of compliance with your obligations, and whether you should already at that point notify your customer. And then there are rights towards your supplier. You should check whether the grounds claimed by the supplier included are indeed the force majeure events as foreseen by your force majeure clause in your contract. Consider whether the supplier showed a reasonable effort to overcome the obstacle, and whether it complied with other duties under contract. Thank you very much. Unless Martin wants to add anything further, we can now move to answering your questions.
Thank you, Matej. No, I believe that was by way of introduction, force majeure 101 under Slovak law, as much as we want to say at the beginning. Now, I was offering the participants to ask questions via the chat feature of WebEx. So those of you who are behind your computers, feel free to use the chat function, and you can either send a question privately to me or Matej, or publicly to everybody else. And if you send your question privately, we will not mention your identity. We will just say the question. Those of you who are on the phone and want to ask a question, feel free to do so right now. But for that, you are probably going to have to unmute your phone first. So let me open the floor for questions. Okay, we are not hearing any questions for the time being. So maybe let me ask one question. I have seen that Ronald Blaško from AmCham, the executive director of AmCham, is on the line. Ronald, do you have any first-hand experience or any reports from the AmCham members about how they are coping with the coronavirus, and do you think the topic of force majeure may become relevant for the membership as time goes by?
Question. Thank you, first of all, for organizing or co-organizing this very first webinar with AmCham. We are very glad that we can be in touch with our members as well as with you, at least via this modern way for which we have to for sure get used to for the coming weeks, if not months. And coming back to your question, no, so far we have not received any question from our member regarding this issue, but given the interest in the topic of the webinar, I think many companies are facing, a decision and kind of deliberation whether this clause applies to their contracts. So I think it's very topical, and I'm very glad that you've been able to present your views and your expertise, and I'm sure that many of our members will come back to you with their questions. So just to sum it up, so far we haven't received any specific questions regarding this topic, but given the interest of the members, I think this topic is actually very, very topical. Thank you, Martin.
Thank you, Ronald. Maybe one additional comment from my side. Some of you would have heard me talking about certificates or confirmations issued by chambers of commerce that there has been indeed a force majeure event. And you may have the question whether the American Chamber of Commerce is able to issue such a certificate. Unfortunately, the answer to that question is no. Under Slovak law, it's only the Slovak Chamber of Commerce and Industry who is able to issue such a certificate. However, I'm pretty sure that the American Chamber of Commerce can facilitate through these presentations and contacts with people who are knowledgeable of the matter, a way how companies who are affected by coronavirus could seek and obtain such a certificate. Are there any further questions? And given the fact that we have, the last time I counted, looks like we have almost, well, close to 50 people joining this call. So that is quite a brain trust we have there, and almost half of them are fellow lawyers. So to the extent other colleagues who are on the line would have made other or interesting experiences with looking at and applying force majeure clauses in these testing times, we would like to hear from you as well, and I think this would be the right platform to share those experiences with the rest of us. Okay, looks like we only have shy people attending today's conference call. Michal Krčmery, any additional questions from your side that we would be able to answer? Something that we didn't answer to your satisfaction?
Thank you, Martin. Thank you for the presentation. I'm pretty sure that thanks also to the last slide that you posted here with the contact details, that some members might get back to you with more specific questions. However, I actually see there's one specific question from Mr. Stredansky that was just posted. So maybe if you want to have a look on that one as well. So there might be one or two more questions from the audience right now, but I'm pretty sure there will be some asked directly to you over the next couple of days through emails or phone calls. But if maybe you can have a look at the question that was just posted.
Sure, and thanks, Peter Stradansky, for asking a great question. To those of you who are not on the chat, let me read that question out loud. Hello, amazing webinar. That's great. I would like to ask whether you consider already approved governmental regulations as the reason which constitutes the termination of lease agreement under paragraph 9, subsection 3, B, according to the Act on the Lease of Non-Residential Premises, so it's 116.1990. Peter, we have looked at that question, and the answer is not so simple. It really depends on the lease agreement in question. It depends on the type of premise that is being rented. Is it in a shopping center? Is it on the street? Is the shopping center open to the public because it has shops that sell food or medicines, or is it something else? So I am unable to answer that question on a general basis, but if you would ask me hypothetically whether the current situation could, under some circumstances, represent a ground for termination of a lease of non-residential premises, the answer to that is potentially yes, but I think the burden of proof and the threshold that would have to be passed is fairly high. But if you want, feel free to ask a follow-on question either via this platform or later on, and we would be more than happy to look into it for you.
Martin, can I have a question? Ronald is speaking.
Of course, Ronald, go ahead.
How about payments? You know, like the whole banking system is really slowing down. And, you know, like I'm sure that all the banks are overwhelmed with their, you know, customers asking for payments, postponements, and etc. And of course, their staff is also I mean, banks employees are home office, and simply, you know, the productivity is not so high as it should be or as it could be under normal circumstances. And let's suppose that you get into delay with some payments, but you actually have no problem. You have even cash, or you are supposed to draw some credit. But simply the whole system is it's simply in standstill or simply not working as productively as it should. Does it apply, you know, this force majeure also for this, that you get into some delay because of the you know, objective problem on the side of banks?
Well, that's a very good question, Ronald, and I think we have to differentiate between two different situations. One is where the banking system actually works, but companies are exercising what is natural behavior. They are hoarding cash for worse times because they are expecting that their own customers will not pay them, and they simply delay their own cash outlays as much as possible. And that, to me, would not be force majeure under any circumstances, because there is no objective impediment to the ability to pay, and as far as I know, there hasn't been any impediment in the overall banking system. The other is if the current situation would deteriorate, and let's say the National Bank of Slovakia imposes foreign exchange controls, or there is another regulatory action which would prevent banks from exercising payment instructions in the usual manner. Let's say there is a limit on the individual amounts that can be paid out of bank accounts or withdrawn out of bank accounts, especially for businesses that require cash for their operation. That might be a problem. In such a scenario, which I hope will not materialize in Slovakia, potentially such a situation could represent a force majeure, albeit only of a temporary nature. Matej, anything to add on that?
No, I think you explained it very well. It's
maybe one additional point which wasn't probably emphasized enough yet is the fact that under Slovak law, what is force majeure can only operate to relieve an affected party from the liability to pay damages for non-performance. It does not cure non-performance as such. So maybe, Matej, this is a topic where we could preempt another question. So under Slovak law, if a party defaults on its contractual obligation because of a force majeure, that is still default. However, that party is not liable for the damages caused to the other party by such inability. And that is, put it very, very simply, and there are more, there can be more context around that statement. But in this respect, Slovak law differs from some other jurisdictions which do recognize force majeure. I think we have a new question in the chat. Okay, let me read it out loud for those of you who are not on the chat. Hello, I would like to ask your opinion if a company could possibly claim force majeure in the current situation if restrictions which interfere with its contractual obligations was not imposed by any authority but was implemented by the company itself. So I guess this is something like a self-quarantine. For better understanding, such company is operating a strategic infrastructure and the company has implemented these measures in order to prevent a failure of basic services like delivery of electricity. And you can tell that the author of this question doesn't work in the milk production business. That's a great question, and thank you, Lubomir, for asking it. And I think the question can be rephrased as, do self-quarantine measures or self-preventing measures act in a way which can trigger the force majeure clauses and the relief under them? And you know, without being able to look into the particular situation, again, I'm afraid I have to say it depends on what the contract provides. If the force majeure clause in your contract does provide self-quarantine measures or preventive measures taken in the face of a pertinent threat to public health as a force majeure, potentially yes. But to the extent you would be able to procure alternative supplies of the relevant goods, such as electricity in this case, I think force majeure doesn't relieve you of the obligation to try and look for alternative supplies, because that's part of the obligation to avert or to make good on the or to overcome the obstacles that are put in place as a result of the force majeure event. So I'm not sure if I answered that question to your satisfaction, but it's nonetheless a very good question, and I'm pretty sure that other companies who have had to face similar situations will be interested in it. It also reminds me of another situation which we discussed over the last days, and that is, what if you have a company, a business that is able to operate under these current circumstances, but where it would only take one employee to fall ill with COVID-19 for the entire operation to have to be quarantined and shut down? And to what extent measures taken by the company to, for instance, split the shifts and separate employees into different teams so that they are not as productive as they used to be, but at least they are they are separated from each other, so there cannot be any cross-contamination, and it leads to delays in supplies. To what extent that could be a force majeure event? And again, when we looked at that, the answer was it really depends on the contract. As a matter of Slovak law, if there is no force majeure clause and there is non-performance or not timely and full performance, would that represent force majeure? I would really love to be the lawyer arguing that case for one or the other side before courts, but until the Slovak courts tell us something wise about this point, I don't think I can give a definitive answer.
Maybe just a note to this example that, as Martin explained, in force majeure regulation under Slovak law, there are basically two obligations of the affected party: to overcome and to avert. So such circumstances could be, depending again on a particular case, but could be deemed that the party actually tried to avert an event that could cause a force majeure, and it could help their case. That it took such measures, even willingly, not mandatorily imposed by the government.
Okay, let us wait if anyone else would have additional questions. And also, colleagues who are not in-house, who are also from law firms, although this is an Allen Overy presentation, and I know generally there is the professional courtesy sentiment that other lawyers shouldn't steal the show, because we live in such uncertain times, and this is such an interesting topic. To the extent any of you would have any interesting observations or thoughts on this point, we would be more than happy to hear of them, either via the chat or directly, if you can make yourself heard. I think my request has been heard by Eric. So Eric has asked the question, and again I will read it out loud for those of you who are not on the chat. What about the following situation? The landlord does not breach any of its obligations under the lease agreement, i.e. the premises are all fine and in good leasable conditions, but the entrance to the premises is limited, restricted. Premises are not in shopping malls, and the restriction is by government measures. My opinion is that such limitation restriction does not entitle the tenant to claim force majeure. I believe that none of the landlord obligation under the lease agreement was breached, and its obligation is to lease the premises in leasable conditions, and the fact that the tenant cannot enter such premises is not its problem, however harsh that may sound. I think that is a valid view, Eric, and I think you come at it from a very interesting and logical angle. I think there could be a contrarian argument made as well, that if the lease agreement provides for the lease of premises which are to be used for a specific purpose, and that purpose is impossible because of the government restrictions, because of the inability to access the premises, I believe the tenant could try to formulate some counter arguments against that. At the end of the day, I'm afraid it will have to be decided based on what the contract actually provides, and I'm sure these situations, like you described, will lead to a number of disputes which the Slovak courts will have to decide sooner or later. So it's going to be an interesting couple of cases for us lawyers. We have another question. Hello, my question concerns the area of services. If a client has prepaid a service that should be provided to him at a later time, but at that time he chooses not to utilize it as a choice, rather than a regulation preventing it from being provided, could he request a refund? Well, the simple answer, he can always request a refund. If he has a good lawyer, he might even get away with it. Whether he is entitled to a refund under the terms of the contract, again, depends on what services are we talking about. I mean, as we all know, some of us have had summer holidays already booked and flights across the continents booked, and these are just not happening. But not only because currently airlines are not operating, but also because customers decide in the current unease about the situation that they would rather cancel their existing bookings. And to what extent the existing scare of the coronavirus is a valid reason for that cancellation and would give rise to a full reimbursement claim. Again, that would depend on the underlying contract and also perhaps on whether the relationship in question is between a consumer and a provider or between two businesses. So this distinction has to be also borne in mind that B2B relationships are usually less stringently regulated than consumer business relationships. Again, I'm not sure if I answered that question to your satisfaction, Jana, but if you have something more specific in mind, I would be more than happy to hear from you after this presentation. Uri asks a question which actually I wanted to mention, and that's a great question. So Uri is asking, what is your opinion on payment of tuition fees for private schools which had to close due to government measures? And I am myself a proud father of two children who go to not very expensive, but nonetheless private schools. And I have had to pay until the end of the school year. And now that tuition is either not happening at all or happening via computers, which we have to provide over our internet lines. And I think I've actually discussed this point with our own school, and the argument of the schools is that they make the teachers available as much as possible under the circumstances. So teachers do assign homework, they are available for online courses, they are simply unable to have in-person classes at school. So whilst this represents an impediment, and probably the schools will consider giving a discount of some sort, I don't think it represents a complete inability of the private schools or schools in general to provide tuition. At least that is the argument I keep hearing, and an argument that I have some sympathy with, because once this all comes to an end and we will again be able to live normally, we would all want our children to have a school to return to. And if all the private schools go bankrupt because all the parents decide not to pay anything for the time when their children stay at home, I don't think that would be such a great result for the society and the economy as a whole. But I think this is the parent in me speaking more than the lawyer in me speaking, and I'm pretty sure the legal argument could be made on a more formal basis there. We have another question, and it's wonderful that we have started to have questions coming in. Patricia asks, what is the relationship between force majeure and contractual penalties? Thank you. Matej, I think you're a good one to answer that one.
Yes, as we mentioned in our presentation, unless the contract stipulates otherwise, the force majeure does not relieve a party from his liability to pay contractual penalty. So I'm not sure if there is any much more to that. If you have a special provision in a contract which does not seem clear, you may then forward it us and we can discuss later. But I think that's the answer. Yeah, and there is one more point that the court actually can decrease the contractual penalty to the level of the actual damage. This is one of the options that could be argued in a potential disputes, of course. Yeah, we see now that the question was asked because, okay, well, I'm glad that we are able to help you.
Okay, we have another question, quite a specific one. Let me read it out loud for you. Assuming a contractual relationship does not exclude the application of the civil code to the commercial lease relationship, in your opinion, does the provision of section 673 of the civil code in general apply to these commercial lease relationships? I will also share some of our findings. Okay, Peter, why don't you share your findings first, and that will give us some time for me and Matej to research our thoughts on that provision of the civil code. Peter, would you like to say something on that topic? And because if you are speaking, we can't hear you. You are probably muted. Okay, so Peter says that he will be speaking in just a second, probably some technical glitch, but I can see that Peter, you still look as if your line is muted. Let me see if we can unmute you. If we can. Okay, now I think you're unmuted. So why don't you try to say something? Maybe we can hear you. No, it looks like it's impossible. Okay, well, so in the meantime, let us just for the benefit of the others on the call. So Peter is essentially asking whether section 673 of the Civil Code might in general apply to a lease relationship. For those of you who don't know the Civil Code, section 673 says that a tenant is not obliged to pay the rent if, due to faults of the rented thing, which the tenant did not cause, it was unable to use the leased property in the manner agreed, or in the manner which is usual for that property in question. And that is just the paraphrasing. The translation might not be that great. Well, again, I expect there to be the arguments going in different directions on this point. But I think we would have to start from the premise that if we are talking about a lease of non-residential premises, those premises, as such, they continue to be usable, usable in the technical sense, just like they were before. In other words, there was no fire, there was no flooding. The premises do exist. They may even enjoy continued supply of water, electricity, and all the utilities. You just simply cannot access them, or you can access them, but your retail customers can't. And I think on that, the debate will be whether the inability of third parties to use the premises for the agreed purpose is something that could qualify under section 673. I would really be interested in your view, Peter, on that. I think this is something that probably I would shy away from answering right now on the spot. But nonetheless, it's an interesting topic for discussion. You could probably make the argument that the inability to use the leased property may not only be of a technical sense, but also in the legal sense, that if you are legally prevented from enjoying and utilizing that property, that should also qualify. I would have some sympathy with that argument, and I'm pretty sure there will be courts in this country that would have sympathy with retail premises tenants, and will probably drive the jurisprudence towards that. And in fact, we have already seen some legislative efforts in other countries. I understand Hungary and France have already passed legislation protecting retail space tenants against the adverse effects of the inability to generate income in their premises. To what extent that might happen in Slovakia, we are still to see, because the government has not fully published yet the list of measures that they want to take in order to alleviate the impact of coronavirus on the Slovak economy. Okay, I think that pretty much takes up all the time that we envisaged for this webinar. Unless there are any last-minute questions that people would like to ask, I would probably pass the floor to Michal for some concluding remarks.
Martin, Matej, thank you very much for the interesting presentation, as well as your willingness to answer the questions. As we could all see, after some initial hesitation, the questions started to come in. So that's good, and I'm pretty sure, as I said, more questions will come in, more specific questions will come into your emails in the next couple of days. So without further ado, I would like to thank everybody for their active participation. This was the very first webinar we organized in order to help our members in these difficult days of uncertainty to better orientate themselves in all the options that they have. We'll continue next week with several interesting webinars. On March 31st, on Tuesday, we'll learn more from our colleagues from IBM about how to be more effective on home office. And then on the 2nd of April, we'll have a discussion with on financial issues with our members from Slovenská sporiteľňa. If any of you, our members, are willing to offer a helping hand to other members, to offer your expertise and organize a webinar with us, please come back to us. We're open for further topics, and we're planning more webinars to be organized in the upcoming weeks as a help to our members. And we also prepared a special section on our website with all the relevant information about COVID-19. So thank you once again, Martin and Matej, and thank you everybody for joining us for a call, and we wish you a nice rest of the day, and enjoy the weekends, and most of all, stay healthy.
Thank you, everybody. Thanks a lot. And just to know that we will be publishing more materials on COVID-19 and the effects on business and legal landscape on our website, and we will try to share that as well with the AmCham member community. So thanks again for taking the time to log in, and we look forward to seeing you in person, but also virtually very soon. Thank you. Bye-bye.
Bye-bye.